as I was saying, there's a lot of uncertainty. The law is brand new, it's really in flux, and for the non-lawyers in the room, the way law is made is that there's a new law that comes from either legislation or a court case like this one, and then the courts interpret it and apply it, and that develops and fleshes out the law. So when, like Dynamex being brand new, it's not developed and refined yet. It's just this one decision kind of sitting there confusing us all. And as time passes, it will become more refined. We'll get a greater understanding. We'll see how courts apply it in different contexts, like to an event company or whatever. And there may be other changes. There are 2 different bills pending in the California legislature trying to do opposite things with Dynamex. One is introduced by a Democrat from San Diego. Her name is Lorena Gonzalez. This is Assembly Bill 5, and she is pro-Dynamex. So she is trying to codify it, make it into an actual statute, and she's trying to expand it to be applied not just to the wage orders, like I mentioned, but all aspects of employment law. And even more dangerously, if you're an employer, she is trying to confirm that it applies retroactively. So that's kind of a nightmare if you're an employer, right? So just to take a step back on that, typically when a new law is passed, the new law is effective January 1, 2019, and it applies forward from that date, right? But what the Dynamex court said, which is dangerous, but they just kind of said this and left it sitting there, was that we are interpreting existing law as opposed to making new law. We're interpreting the law as it already exists. And if you follow that logic, this is what should have been happening all along, looking backwards. And so, like I said, they made that comment and they just kind of left it sitting there. And the employment lawyers are all debating, well, is it retroactively applied or not? And I think very technically, it may well be. And this state assembly person, Lorena Gonzalez, wants to write into the law that it applies retroactively. Now, I'm a defense lawyer. I represent employers, right? So to me, that is incredibly unfair, because how are employers supposed to know? In my mind, it's a big change to the law. And how were all my clients supposed to know that this new test applied? But that's what may happen if her bill passes. On the other hand, there's Assembly Bill 71, introduced by a Republican state assembly person from Lake Elsinore, California. Her name is Melissa Melendez. She basically wants to ignore Dynamex and go back to Borrello. So both of these bills were introduced when the current legislative session opened last December, and they're both very early on in their process, and we don't know what's going to happen. One thing I do know, just from following them a little bit, is that the Democrat bill, Lorena Gonzalez, who wants to expand Dynamex, she has been lobbied by some trade groups that want to be exempted. And I can't tell you what all the trade groups are, but one of them I know is doctors. And they want to be exempted. So what they're saying is, even if Dynamex applies broadly, we doctors still want to be able to be independent contractors. And I looked at, I know it's coming in tonight, of course, so I looked at it to see if there were any exceptions in her bill that would apply here, and there aren't. So it might be fruitful for lobbying if anybody wants to go that route. You can follow these bills if you want. You can look them up and follow the legislative process and see where they are. And I'll be checking them, but I don't know how long we expect. You know, one thing I do expect is that there's going to be a lot of feedback and discussion and lobbying and pushback. So I wouldn't expect anything to happen super quick. I'm getting a lot of questions from my clients, of course. What do we do with this? And like I was saying, you know, as their lawyer, I feel that my professional responsibility is to give them the best and really most conservative answer that I can. And I'm not always the most conservative lawyer. I get it that small businesses have to run their business too. And so many times I will say, this is the proper legal answer, but maybe we can make that work for you. Here, I'm saying that to some extent, but because there's so much uncertainty and we don't know exactly what courts or the Employment Development Department or the Labor Commissioner are going to do, I'm telling businesses, this is the correct legal answer. Almost everybody you ask me about should be an employee. But there's a risk assessment, right? If you've got an events planning business and you basically cannot run your business if you have to reclassify everybody as an employee, maybe you decide, I'm going with it for a while and I'm going to see what happens. But it's sort of how risk averse are you as the business owner or manager. I want to talk a little bit about how these rules are enforced and, you know, kind of bottom line, how do they affect you as a business owner or an organization management. So as I mentioned, Dynamex specifically applies to cases brought under the wage orders. The wage orders are rules put out by the California Labor Commissioner, which is part of the Department of Industrial Relations, and the wage orders govern things like wages, obviously, work hours, wages, overtime, minimum wage, that kind of thing. Interestingly, wage orders and all of these rules apply to non-exempt employees. They don't apply to exempt employees. That's a long conversation, what's non-exempt versus exempt, but just very briefly, exempt is more management, higher level, professionals, managers. Non-exempt is more your actual workers. And so if you've got management level employees, this is less of an issue to be concerned about, just something to know. Employee classification, independent contractor versus employee, may also be looked at by the Employment Development Department, the Federal Department of Labor, which is similar to our labor commissioner, but on the federal level, your workers' compensation carrier. And it may also be the basis for a lawsuit by an employee who feels they weren't treated fairly. So you've got sort of all these different forums that these issues can arise in. Typically, the labor commissioner and the Employment Development Department will not unilaterally generate a case against an employer. So for the labor commissioner or the Employment Development Department to come after a company or to investigate a company, what typically needs to happen is an employee needs to go in and make a complaint or make a claim for unemployment insurance or state disability insurance. And then the worker goes in and makes the claim. The company gets notice of the claim. The company says, oh no, that person wasn't our employee. They were an independent contractor. They respond that back to the EDD or the labor commissioner. And then the labor commissioner says, oh boy, we've got a conflict. Now we're going to audit this employer. And that's one way that the issues can come up. Something that the labor commissioner or the Employment Development Department will initiate on their own, though, is sort of an industry-wide audit. If they see, for example, that they think a particular industry is going to have a lot of violations in a certain area, I mean, and it could be the arts industry in this context, because they may realize that so many arts organizations use a lot of independent contractors. They may say, we're going to just start randomly auditing arts organizations. I had this come up in the context of, I happen to represent a good number of Mexican restaurants, and the labor commissioner decided to audit Mexican restaurants because they had a feeling, I don't know how, that there were a lot of wage violations in the Mexican restaurant industry. Unfortunately, they were correct. And so a number of Mexican restaurants got penalized for all these. I mean, I say unfortunately because I represent them, but good for the workers who weren't getting all their overtime, right? So That's one way, or a couple of ways that these issues can come up. Another way that they can come up, and this one's a little bit scary in my experience, is a worker makes a workers' comp claim. And if it's a worker that the employer didn't think was an employee, and they respond to their workers' comp carrier saying that person was not an employee, they were an independent contractor, that is very likely to trigger an audit of all the employment classifications in that company or organization. And I see that particularly arise with employers that use state fund for their workers' compensation insurance. In my experience, they're very aggressive in evaluating classification. There can also, of course, be a lawsuit. An employee may decide, or a worker may decide, wow, all these years I was working as an independent contractor, I didn't get paid my overtime, I didn't get my rest and meal breaks, I didn't get any employee benefits, but really that company was controlling me. They were telling me what time to come up. You know, they go get a lawyer or they go to the labor commissioner, and that can turn out to, you know, raise these issues as well. What happens? What are the penalties if an organization or a company is actually in violation? This can be an expensive lesson, as I've said to many of my clients. Like we mentioned, if it's a wage claim, which most of these are likely to be, there's a 3-year statute of limitations on that claim, which means that from the date the claim is filed, the worker can look back 3 years for unpaid wages, overtime, employee benefits, unpaid sick days, which can add up quite a bit. There are penalties under the labor code. There's interest. If the employee hires a lawyer and goes to court and they win some wages, they will be awarded their attorney's fees as well. In addition, under the California Labor Code, in the last few years, maybe about 4 or 5 years ago, they increased the penalty to be imposed on an employer for willful misclassification of workers as an independent contractor instead of an employee. And it has to be willful. It can't be just, oh, we didn't know. But the minimum penalty for each incident now is from $5,000 to $25,000. So if it's one worker, that's not such a big deal, but if it's 100 workers, that's a pretty expensive proposition. One thing that I wanted to highlight as an important issue is retaliation. It's human nature for an employer to be unhappy if an employee comes to them and says, hey, you know, I think I've been misclassified, or I think I've been sexually harassed or discriminated against, or whatever wrong the employee might want to raise. And it's human nature for the employer to say, I don't like this person anymore, I don't want to work with them anymore, let's just get rid of them, kind of thing, or let's demote them, or let's stick them in a back office with no windows, or whatever it might be. That's a separate legal wrong to retaliate against a worker who raises a legal right in the workplace. So something to know if you're the worker who might want to raise that right, and something to know if you're the employer. You have to be super, super careful not to do anything that looks retaliatory in response to somebody raising that kind of issue. And just we kind of talked about this already, but I did want to just very briefly look at it from the other side, because as an employment defense lawyer, I tend to be biased to the employer side. But if you're a worker and you think you've been misclassified, or you have questions about your classification, what do you do? What should you do? Or, you know, what should an employer maybe expect from a worker who might have those concerns? My first thought is, for the worker, do you really want to be an employee? Because as an independent contractor, even though you don't get employee benefits, you have autonomy, you have freedom, you can write off your business expenses, you can take vacation whenever you want. There are a lot of pluses to being an independent contractor. But if you do think you've been misclassified, and you want to raise that issue with your employer, I would come at it from a place of kindness and support and providing information rather than going on the attack. Because even though it's illegal to retaliate, nobody likes to be attacked and told they're wrong and, you know, I'm going to sue you kind of thing. So I would like to think that if a worker comes to an employer and says, hey, you just might not have realized, there can be a positive conversation. Hopefully the employer calls their lawyer or, you know, does some research to figure out what the right answer is and, you know, works it out and can come to an amicable resolution. So those are my comments.
Thank you very much for watching. If you would like to see more videos by California Lawyers for the Arts, please like and subscribe to CLA's YouTube channel so we can provide full-service live streaming programs soon. Our channel will be producing videos that cover all kinds of artistic, entertainment, and intellectual property legal issues. You can also find our videos on Facebook and livestream.com.